All right, do we have Terrence Fonfield? Terrence Fonfield. Nope. Robert Ragland. All right, Mr. Ragland. And Mr. Lyles, one of his cases has been indicted. Did you hear me, Mr. Lyle?
Yes, Robert Ragland. Yes.
Right. Okay. So one of them has been indicted. So we'll hear the one case now. Hey, Bostic, let's see. Do we have Ms. Holmes here? All right. It's going to be position 2. Robert Ragland. One of these cases was indicted. So we're just doing the one. Bostic 22 CP 213699. Robert Ragland. 117 days without indictment. There is a $50,000 good bond as of November the 4th. Arson in the first degree, aggravated assault, arson in the first degree, aggravated assault. Pre-trial.
Judge, do we have a clerk on? I'm sorry.
Yeah, we do. Ms. Holmes.
Okay.
Judge, in regards to Mr. Ragland, 25 prior arrests, 4 arrests for probation violation. The case indicted was 23 SC 186198, aggravated assault, terroristic threats was added. Firearm during, firearm by, assigned to Judge Whitaker, currently on probation, 16 SC 1422825, aggravated assault. Sentenced in 2017, 4 years confinement, 6 years probation. Has at least 3 other felonies: controlled substance, aggravated assault, theft by taking, aggravated assault, 4 misdemeanors. Nothing further.
All right, go ahead, Mr. Law.
All right, my client is age 39. He has a large family presence in his life here in Atlanta, where he's lived for a long time. His mother, brother, sister, and extended family all live around him, and he lives with his mother and sister. He works as a babysitter full time for his brother-in-law and for his brother and sister-in-law, who is actually a jail guard at Fulton County Jail. He watches their kids full time. He has been through high school, and of note is that he does have mental health issues, as he's been a victim of a crime before, violent crime. So he has PTSD, and it's hard for him to walk from being shot from that crime in 2015. So it's not very conducive for him to be in jail. So we are requesting a reduction from the 50,000 to 25 total.
What says the state?
Good evening, Your Honor. We actually don't believe the bond should be lowered based on the fact that the defendant was on probation at the time that the new offenses were committed, as well as he returned to the scene within minutes of the first attempt. And so we don't think he's a candidate for a lower bond, Your Honor. So the 50,000 seems appropriate.
Mr. Lyle, where's he going to live? Is he going to live in Fulton County?
Let me see. It is Atlanta, Georgia. Yes.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 905 Hubbard Street Southwest. No further contact with Edward North. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical. Since he babysits, he doesn't necessarily need it for work, does he? Do they bring him to his house, or does he go to them?
He goes to them.
All right. So he can do it for his babysitting job. He has to supply that address, proof of hiring being the babysitter, and a schedule, the exact time he's going to be there, so that the ankle monitoring company will know. He'll have to let you know, and the ankle monitoring company, so that they won't end up revoking his bond. 10 on count 1, 7 on count 2, 10 on count 3, and 7 on count 4. Ms. Holmes, that's 10, 7, 10, and 7. Best of luck to you, sir. You can leave the booth. I got Terrence Fonfield. All right, thank you. Mr. Ragland, you can go ahead and leave the booth. Terrence Fonfield?
I mean, I'm here for him, Judge. Are you calling for his to be at the
I'm calling
booth?
for him. If you're
Yeah.
Terrence Fonfield, wave your hand. Who is that in booth 3?
Judge, I'm not sure, but
Let's see. Hold on. Maybe that's
Terrence
Roderick
Fonfield
Nance.
should be in Marietta Annex.
All
He
right,
is.
Roderick-
Yeah.
All right, that's Roderick Nance. Mr. Hudson, you here? There you go. All right, hold on. Mr. Hudson. I saw Jacoby here earlier. Jacoby Hudson.
He was here, Judge.
Terrence Fonfield, I'm here.
No, Jacoby Hudson. All right, let's go back, Mr. Olaf, since we'll be back with you there, Mr.
Your Honor, Attorney Andre Smith here. Mr. Hudson, I just got off the phone with him. He's trying to log on. He should be on very shortly.
Okay, let me go back to Mr. Fonfield. All right, Mr. Olaf, this is Bostic, it's position 922 CP 212415, Terrence Fonfield, 165 days without indictment. There's no bond as of September the 17th, burglary in the second degree. Pre-trial.
In regards to Mr. Fonfield, 18 prior arrests, numerous felony convictions, purchase, manufacture, and sale. First offender, 2014 firearm by a convicted felon, 2 counts, couple of FDAs, couple of arrests for probation violation on probation, theft by receiving, sentence 3/8/2022, couple of open cases, 22 CP 212416 and 417, both are burglary in the second degree, nothing further.
Go ahead, Mr. Olaf.
Thank you, Judge. Mr. Fonfield is 30 years old. He's been here in Georgia his entire life. His entire family lives here. He has 5 children. He's got 2 4-year-olds, a 10-year-old, a 14-year-old, and a 16-year-old. He has the address on file is good. He lives there with his girlfriend, and he went all the way through the 12th grade. He's definitely interested into getting into a GED program, and we would consent to that being part of the conditions of the bond should the Judge Graham one. And he was working at a skating rink as a manager there part-time, and he can go back there if he gets out on bond. I'd also like to say that he went in and he was became a trustee within about 2 months after being incarcerated. He's been there ever since. He's if you look at the picture, he looks different. He's cleaned up his look, and he's taking everything very seriously about trying to get out and get back into the world and be a productive citizen out there. We just asked that he doesn't, again, he's been incarcerated since September, over 5 months, so he doesn't have any money really. So we would just request a reasonable bond, Judge.
Is that a Fulton County address where he lives?
I believe it's College Park.
So you don't know if it's on the Fulton County side or the Clayton
I
County
have
side?
to look it up, Judge. My
All right,
apologies.
what's that the state?
Your Honor, the fact that there are actually open cases and based on the same or similar type of behavior, the state actually believes a reasonable bond for this defendant would be $45,000.
Right, no drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendant. Garion, Garion, Holder, Holder, no further contact with Reginald Miller. Stay away from 5415 Old National Highway. That's the New Orleans Daiquiri store. You can have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical. Is he going to get a job? If he gets it, he can go leave work on his GED and employment as long as he supplies proof of enrollment, where he's going to go, proof of employment, name of the employer, schedule, and the exact location he's going to be working. He has to supply that to the ankle monitoring company and to you so that you can supply that to the state. $30,000 good bond. Best of luck to you, sir. You can leave the booth.
Thank you.
Thank you, Judge.
Thank you. All right, let's see. Mr. Hudson get back on yet?
So.
Yes, Your Honor. Good afternoon. Can I have about 10 minutes? I'm pulling up at my office.
Okay. How about Jade Shabus? ACDC?
Yeah.
It's
Good
21,
afternoon,
Bostic, 22 CP 213941, Jade Shabus, 108 days without indictment. There's a $30,000 good bond as of November the 14th. Got willful obstruction of a law enforcement officer by use of threats or violence, felony, aggravated assault. Free trial.
2 prior arrests. The other arrest is an open case, 22 CP 207732, obstruction, felony, 3 counts, nothing further.
Go ahead, Mr. Mitchell.
Yes, good afternoon, Judge. Ms. Chavis, she's a 20-year-old resident of Fulton County. She's lived in the metro area her entire life. Entire family lives in the Fulton County area. At the time of arrest, she was a sophomore at Savannah College of Art and Design, where she was majoring in fashion design. Initially on this particular case, as you just stated, she was given a $30,000 bond, but then she picked up the new case, that 7732 case, the willful obstruction and willful interference. And I think that's what pulled the bond on this particular matter. There's an issue there that we've identified, and we think between her parents and we have rectified. She's going to be entering the young adult psychiatric and addiction program at Ridgeview Medical Center. And I think that would be because both cases have involved alcohol. And we think that that's going to be something that can assist her going forward, because again, that second case was very similar underlying conditions. Being that she's been in jail this entire time, she's missed the start of the semester. So she's going to be moving back in with her parents upon release. And so that actually gives her a good opportunity to complete this program at Ridgeview and hopefully be successful moving forward. She'll be a good candidate for bond at this point, Judge.
So is she going to live in Fulton County?
She does live for Fairburn, Judge. Mhm.
All right. What says the state?
Your Honor, we actually believe that the bond that has been set already is appropriate under these circumstances based on the nature of the offense. And so we will leave it to your discretion, Your Honor.
All right. So, Mr. Mitchell, are they going to let her return to 40 Scad Way?
40 Scadway.
That was the incident location.
Yeah, they will. So they're allowing her back to the school afterwards. It's just that the start date has, since the school year has already started, because we've been in contact with the school. We've explained the situation because she actually had an evaluation done at the school too, as well as a precursor to her entering the Ridgeview program, because they're aware of kind of some of the issues, and they've been trying to work with her to kind of get things taken care of.
Okay, so I think the 40 Scad Way is where she lives, so she'll be living with her.
Oh, the Scad. Oh.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 40 Scad, SEAD Way Northwest. No further contact with Officer J, MACH, unless it's in their official capacity. No further contact with Crystal Rowland, ROWLAND.
And Your Honor, do you have a position? I don't know if that individual is a student at the same location, whether or not they would end up in the same classes. So can you speak towards that?
Yeah, Mr. Mitchell, do you know if that, I mean, obviously they were roommates, so she got to stay 200 yards away from her.
Yeah, they were in the same class together, Judge. Yeah, that's where they lived in they were living in the same dorm room together. I'm not sure as far as enrollment in class. I know she's not going to be enrolled at least until the fall, coming back into the SCAD program. I'm not sure class-wise how she's going to be enrolled and what classes they would actually share together. I'm not sure in reference to the roommates major.
All right. Well, I guess you could just file for modification. You can email
Yeah.
Broderick and let me know if something needs to be amended. By then, they should be able to get in touch with the alleged victim. Have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and you're getting into a rehab facility.
Yes, Judge. Ridgeview.
Okay. So participate in any sort of rehab at Ridgeview or any other place that your parents and or lawyer get you into. We'll do 7 and 12. 7,000 count 1, 12,000 count 2. Best of luck to you, ma'am.
All right. Thank you, Judge.
JCDC.
Thank you, Your Honor.
All right, Freddie Caldwell. We got Mr. Blevins on.
I am here, Judge.
Freddie Caldwell, wave your hand. Not there yet. Carlos Brandon. All right, Miss Bumpus. I think I saw you earlier.
Judge.
All right, here we go. It's position 23, Bostic 22, CP 214083, Carlos Brandon. It's 102 days without indictment. There is a $7,030 split bond as of November the 19th for possession of scheduled to control 2 substance, possession of a firearm or a knife during the commission of or attempt to commit certain felonies, possession of a firearm by a convicted felon, tampering with evidence, possession of marijuana with intent to distribute, driving erratic or improper lane change, misdemeanor obstruction, possession of drug-related objects, and another improper or erratic lane change. Pre-trial.
In regards to Brandon, 25 prior arrests, 2 FTAs, 2 arrests for probation violation, couple of felonies, obstruction, cocaine with intent, just cocaine, theft by receiving, Open cases 21 SC 179399, Schedule 1 or 2, 22 SC 181, 103 firearm by, he's on probation. 1 year confinement, 7 years probation. Nothing further.
All right, Ms. Bumpus, we've got 120 grams of weed and 30 oxy. Go ahead.
Your Honor, well, as you heard, my client does have a significant criminal history. However, we do think that there are some issues in this case that will, show that he is not guilty. And we're just asking the court to set a reasonable bond. I mean, right now, I know he has a bond on everything but those two, but anything over 30,000 in addition to that would leave my client in no bond status.
There's 4 counts he doesn't have short bond on. Go ahead, Ms. Broderick.
Your Honor, the fact that Mr. Brandon actually has 2 FTAs, 2 open cases, and he was on probation at the time that this took place shows that there's a high likelihood that he would reoffend, Your Honor. And we are actually asking for 20,000 on each charge, Your Honor.
Ms. Bumpus, is he going to live in Fulton County?
Yes, he's gonna live in Fulton County.
All right. No drugs unless prescribed, no alcohol, no weapons, no driving during the pendency of this case. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply name of your employer, proof of employment, schedule, and the exact location you're going to be working. Not sure how you're going to get there, sir. I assume you're going to get there by Uber because you're not going to be driving. So let's see. On count 1, possession of controlled substance, schedule 2, 15,000. Firearm during the commission of a felony, 20,000. Possession of firearm by a convicted felon, 20,000. Count 4, I'll leave that at 5,000. Count 5, I'll make that 10,000. Count 6, I'll leave it at $265. Count 7, I'll leave it at 1,000. Count 8, I'll reduce that to 250. And count 9, that's $265. You got that, Ms. Holmes?
Yes, Judge.
All right. Best of luck to you, sir. You can leave the booth.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you, Ms. Bumpus.
Thank you.
1 second here. Let me see. We got Rasan Hutchinson. Rasan Hutchinson. Not here yet. All right. We'll go to the next one here. Dontavius Sims. All right, Mr. Armstrong. There we go. So 14, Bostic 22 CP 214063, Dontavius Sims, 102 days without indictment, no bond as of November the 18th. Possession of firearm by a convicted felon. Pre-trial.
In regards to Mr. Sims, 10 prior arrests, 2 arrests for probation violation. 2011 burglary, 2 counts theft by taking, and 2 was 2014 entering auto theft by receiving. Open case 22 CP 213758, schedule 2 substance, firearm by a convicted felon, firearm during 2012 conviction for simple battery, family violence. Nothing further.
All right, go ahead, Mr. Armstrong.
He's on mute, Your Honor.
Mr. Armstrong, you're on mute.
I apologize, Your Honor. Been sitting here waiting patiently. Mr. Sims was born in 1993. He's approaching 30 years old, Your Honor. He was going to work the day that he got arrested, both times in November. He's trying to save enough money to buy his own car. The weapons that were in the car were not his. He has been in, as you said, he's been in jail for 102 days, Your Honor. He is needed at home with his wife, with his fiance and the mother of his child so that he can help provide with the finances and help raise the child. We're just asking for a reasonable bond, Your Honor. And with 100 days in jail, we believe he's learned his lesson and will make better choices when getting rides to work.
Gonna be living in Morrow, Georgia?
He actually lives right there in Ellenwood.
Okay.
Ellenwood, Georgia.
All right.
He lives with his mother, Your Honor.
All right. Go ahead, Ms. Broderick.
Yeah, based on the allegations in the warrant, we are not opposed to a reasonable bond. 4,500 should work.
No drugs unless prescribed, no alcohol, no weapons. He had any reason to come to Fulton County, Mr. Armstrong?
Well, the bonding company that he's likely to use is in Fulton County. His father also lives in Fulton County, but he spends the majority of his time at his mother's house with his family.
All right, so I'm assuming his dad can go see him in Clayton County. Stay out of Fulton County, sir, unless you're here for court or to see your lawyer. That's the only reason you come to Fulton County. Fill up with gas in Clayton County, go see your lawyer. Don't get a flat tire. Don't stop for lunch. Go straight to court, straight to see your lawyer, and leave. $7,000
Yes,
good bond. Best of luck to you, sir.
Thank you, Your Honor. That concludes my business. May I be excused?
Yes, sir. Thank you.
Thank you.
See, we have, is Mr. Blevins here yet? All right, let's see. Do we have
I'm
Freddie
here, Judge.
Caldwell? Freddie Caldwell, not yet. Rasan Hutchinson.
Judge, that person is in, I received an email in ACDC, and they're gonna get Milton to log back on with that person.
Hutchinson?
Yes, that's what the email that I received said, that they're in ACDC and they're gonna get Milton to log back on.
Oh, okay.
In just a few minutes with that person.
Okay, thank you. All right, what about Bryant Dukes? Thank you, sir. Ms. Lewis, I saw
Yes,
you.
Your
right
Honor,
here.
I'm here.
All right, it's 16, Bostic 22 CP 209620, Bryant Dukes, 269 days without indictment. There's a $70,000 good bond as of September the 19th. Aggravated assault and battery. Free trial.
This is only prior arrest in Georgia, one arrest in New York, and it was for a 2013 conviction of assault. Nothing further.
All right, go ahead, Ms. Lewis.
Thank you, Your Honor. Yes, as you stated previously, Mr. Dukes has been in custody almost 300 days without indictment. He does have the $70,000 bond. However, for him, that is essentially a no bond because he has not been able to secure the funds in order to receive a bond to get out of custody, Judge. At the time he was arrested, he was working full time and supporting 3 children as well as his girlfriend. With that being said, we've also spoken to a couple witnesses who have come forward and stated that Mr. Dukes has been was acting in self-defense at the time he was arrested. So this will also be an immunity issue if and when it becomes indicted, Your Honor. As you heard, he has absolutely zero criminal history, not a flight risk, Judge. All of his ties are here in Georgia. His family is very anxious to have him home so that he can continue once again contributing financially. So we are asking the court to reduce his bond down to, I believe it was 25 and 10 for a total of $35,000, Your Honor, so that Mr. Dukes can actually secure the funds to get out on bond and again, continue working to support his family.
Is he gonna live in Fulton County?
He is in Fulton County, Judge. I believe the last time he was residing at 94 Cleveland Avenue. That's where he would return to.
So, and that's the incident location.
That's correct, Judge. I'm sorry, let me just look over this real quick. It looks like the last time we were in court, he did indicate that he would be moving to Cobb County if he's released from Fulton.
All right, he'll go to Cobb. All right, what says the state?
Yeah, we actually believe the battery could be a $5,000 bond, but for the aggravated assault, we believe $45,000 is sufficient.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Bobby Rembert, Rembert. No further contact with your co-defendant, Romaire, Romaire, Hawthorne, Hathorne. I think you already said no drugs, no alcohol, no weapons. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical. Also employment, as long as you supply the name of your employer, proof of employment, a schedule, and the exact location you'll be working, sir. You have to supply that to the ankle monitoring company and to your lawyer, who will then supply that to the state. I think previously, for some reason, I'm still going to put it on here. I don't know if was any kind of hold. I think I just put this on any of them. But if something comes up and there's a hold, you'll have 48 hours to have that ankle monitor placed on your ankle, sir. 20,000 count one, 5,000 count two. Stay out of Fulton County, sir. The only reason you come to Fulton County's court or to see your lawyer. Don't stop for gas. Don't stop and put air in your tires. Don't run out of gas. Hit 285. Don't run out of gas on 285 that's in Fulton County. That'll be a violation of your bond condition. You understand? Best of luck to you, sir. Thank you, Ms. Lewis.
Judge, we can't run out of gas in Fulton County.
You can't run out of gas, Mr. Hudson. I've already signed a warrant for your arrest.
I'm ready, Judge. I'm in the office. You see that?
All right, Mr. Nance. All right, Mr. Hudson's here. It's 2422 CP 212821. Roderick Nance, 151 days without indictment. No bond as of October the 1st. Aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony. Pre-trial.
No convictions for arrest, open case 21 CP 203383, controlled substance firearm doing nothing further.
All right, go ahead, Mr. Hudson.
Your Honor, this case, the state know the facts of this case, Judge, but it's gonna be our contention. Mr. Nance was acting in self-defense when this happened. I plan on filing an immunity motion if and when this case get indicted. He's not a flight risk, Your Honor. He lives at 270 Linkwood Road, Atlanta, Georgia, 30318 in Northwest Atlanta. At the time of this arrest, he was working at the Clorox Company at 1805 Westgate Parkway, right off Fulton Industrial. Judge, he's not a convicted felon. He doesn't know the alleged victim at all. It was a chance encounter at the gas station. It's not likely to intimidate any victims or witnesses. And Judge, given the nature of the charge, I ask that since he's been in custody over 90 days without the benefit of an indictment, if the court feels that Mr. Nance has to wear ankle monitor, I ask that it be paid for by the state, and that he just have no contact with the victim. He lives in Fulton County, Judge, so he will have to be in Fulton County. We don't know where the alleged victim lives. We don't even know his name, his full name, without the benefit of the warrant. So given that, Judge, I just ask that you set a bond in the amount of $25,000, which is according to the schedule of an aggravated assault.
All right, go ahead, Ms. Broderick.
Your Honor, based on the nature of the offense involving the victim, I believe the victim was shot in this case. We are actually asking for $10,000 on the firearm and $75,000 on the aggravated assault with the deadly weapon.
Has there been any contact with the victim? Looks like it was shot in his left arm.
I have not spoken to the victim, Your Honor.
And Your Honor, we have not spoken to him. We can't. My client hasn't been any jail calls that the state produced saying my client tried to reach out to him. We don't know him, and taking into consideration why I asked for a low or reasonable bond, Judge, Mr. Nance has a presumption of innocence as the court is aware, and he has no criminal history. And present, Judge, I wanted to point out is his father, Roderick Nance Jr., is present in court right now with me in my office.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Christopher Alsobrook, Alsobrook. That's the name of the alleged victim. Stay away from 2472 Martin Luther King Jr. Drive Southwest. No further contact with the alleged co-defendant. I'll spell the name Covissee Dowell, Dowell. No further contact with witnesses Karen Thurman, Thurman, and Isaiah Connor, Conner. You can have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and work. Sir, you have to supply the name of your employer, proof of employment, a schedule, the exact location you'll be working. You have to supply that to the ankle monitoring company and to your lawyer, who then can supply it to the state. 25,000 count one, 10,000 count two. Best of luck to you, sir.
Thank you, Judge. It's always a pleasure, Judge.
Good to see you, Mr. Hudson.
All right. Thank you, Ms. Broderick.
All right, let's see. Freddie Caldwell. All right, let's see. Michael Bateman. 13, Mr. Jerome here. There. Hold on a second, got to see your lawyer. All right, what about Miss Rosenhoover, or it's going to be Miss Rondon for Martavius Gay? Is that you, Miss Rondon?
No,
Judge,
Your Honor, that's not me.
Oh,
good afternoon, good evening. Michael Bernard on behalf of Mr. Gay.
okay, Martavius Gay?
Yes.
There you go. All right, got two cases for Mr. Gates, position 11, position 12. 22 CP 214241, 95 days without indictment, no bond as of November the 26th for aggravated assault and battery. 22 CP 214243, 95 days without indictment, no bond as of 11/26 for aggravated assault. Pre-trial.
In regards to Mr. Gay, 19 prior arrests, currently on probation for burglary, sentence 12319. For 5 years, also for burglary, sentence 11216, 5 years confinement, 15 years probation. Open case 22 CP 214-238, firearm by convicted felon, theft by shoplifting. 3 FTAs, prior convictions, other convictions for burglary and theft by receiving stolen property, 2 arrests for probation violation. Nothing further.
All right, go ahead, Mr. Bernard.
Yes, Your Honor, before you is Mr. Gay. He is a 29-year-old resident of Atlanta, been here his whole life. He's got 2 daughters that he supports, 8 and 9 years old. Graduated from Thorough High School. Before he was arrested, he was actually about to start working as a construction worker. But before that, he was a DHL driver as well as a driver for Amazon. Judge, the first aggravated assault case, we believe that the victim does not want to prosecute. It was a situation where the victim did not want my client to leave, began to strike him. My client then began to defend himself. She called the police as a result of being angry with him for leaving. The second aggravated assault is a situation where he was having a heated discussion with his girlfriend. Another driver, a truck driver who doesn't live in the state of Atlanta, intervenes and begins to strike Mr. Gay. Mr. Gay then begins to defend himself in that case as well. Judge, we believe that Mr. Gay is an excellent candidate for bond in terms of these cases. What we would ask for in this case, Judge, is $10,000 on both aggravated assaults for a total of 20.
All right. Ms. Broderick.
Your Honor, the fact that Mr. Gay has 3 FTAs, he has, I believe, 2 open cases, and he was on probation at the time that both of these offenses took place. We believe that there should be a bond that ensures that we have compliance with the terms of the court. It's clear that there's an opportunity for him to reoffend, and we're actually asking for $50,000 on each aggravated assault and $10,000 on the battery.
Mr. Bernard, is that a Fulton County address he's going to be living at?
Yes, Judge. He'll be staying with his sister. His entire family is from Fulton County, the city of Atlanta. He'll be staying with his sister.
Okay, is that Wellington Walk?
I believe so, but I'd have to double check with him to see.
All right, position 11, no drugs unless prescribed, no alcohol, no weapons. Stay away from 3900 Fulton Industrial Boulevard. No further contact with Joshua Allen. And no weapons, sir. That also means rocks, pieces of cement, anything like that that you may or may not hit somebody over the head with, allegedly. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment, schedule, the exact location you'll be working. Turn that over to Mr. Bernard and to the ankle monitoring company so they can, if you don't do that, sir, they will revoke your bond. 10,000 on each count. Position 12, no drugs unless prescribed, no alcohol, no weapons, no further contact with Jessica Lamar. Stay away from 3804 Martin Luther King Jr. Drive. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical, and employment. Supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Supply that to the ankle monitoring company and to Mr. Bernard, who'll supply that to the state. $15,000 on that. Best of luck to you, sir. You can leave the booth.
Thank you, Judge. That completes my business. May I be excused?
Yes, sir. Have a good evening.
Thanks.
All right, ACDC, do we have Rasan Hutchinson? No, here she comes. I think we got Mr. Weiner.
Yes, Your Honor.
All right, that's position 1 on the add-on, Bostic. 22 CP 215055, Rasan Hutchinson, 60 days without indictment. No bond as of December 31st. Serious injury by vehicle, driving, homicide by vehicle, first degree driving, speeding, and reckless driving. Preach. Rah.
You waiting for me, Judge?
Waiting on Bostic.
Okay.
5 prior arrests, 2 misdemeanors, 1 being an 06 DUI. Nothing further.
Go ahead, Mr. Weiner.
Judge, the only prior conviction is an 06 DUI. There were co-defendants, he and another gentleman that were charged on this. For some reason, the co-defendant got a $15,000 bond and my client was denied bond. They came in front of the court 2 days apart. He's 49 years old, lives here with his mother. His mother is in Grady Hospital. She tried to get on the call, but she could not figure out how to do it with her phone call. She was attacked by wild dogs. She's the only child. Judge, this is a bondable offense. We would ask the court to consider giving him the same bond that the co-defendant received. And he lives at the Riverdale address with his mother, and she needs him there to take care of him.
What's his co-defendant's name, Mr. Weiner?
I'm gonna give it to you. Wait 1 second, Judge. Keith Smith, and the release date was booking numbers 2214365 should be attached to the motion.
All right. Go ahead, Ms. Broderick.
Your Honor, our victim's advocate has had contact with the victim's mother, who, of course, obviously opposes bond. We understand that, that's a right to have a bond discussion and have bond addressed. Based on the nature of this offense, Your Honor, we are actually asking that there be a $25,000 bond for each count.
Judge, the only thing I'm going to say is he should not be treated any different than the co-defendant. The behavior is they were both allegedly speeding, and they cannot figure out who caused the accident that caused the death of the victim. So we would ask the court to consider giving him the same bond.
I'm trying to find his bond. It was his, because this one has 4 counts.
I think the other person had at least 3 counts. I'm looking at the bond information. It should be attached to my motion there, Judge, as part of what we filed. There was a serious injury, driving, speeding, reckless driving. Oh, it's the same 4 counts. And they gave him 15,000 surety and original bonds on the others.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with the family of Mondravius, Mondrevious Lewis. It's alleged he was going 135 miles an hour, so there'll be no driving during dependency of this case unless the bond is modified. Gonna have an ankle monitor paid for by the county with that 24-hour curfew, court, lawyer, medical, work. As long as he supplies the name of his employer, proof of employment, schedule, the exact location he'll be working. And since his mother's ill, he's the only child. He can also, as long as he supplies when he's going to a medical appointment with her, he could take her to her medical appointments. He's going to stay out of Fulton County unless he's here for court, see his lawyer, or if his mother has medical appointments. If they took her to Grady, then he may have to go back to Grady so he can take her there. He's not returned for any other reason.
Ronnie, you mean he can ride with her?
Right, he can ride with her. Yeah, he can't drive, so he can ride with her. All right. We got 10,000, 15,000, 5,000, and 5,000. 10, 15, 5, and 5. That ankle monitor is going to be paid for by the county, sir. Best of luck to you. Stay out of Fulton County unless you're for quarter to see your lawyer. Or like I said, you can ride with your mother. Best of luck to you, sir.
Judge, is that a total 35,000? I'm just trying to make sure I understand what it is.
Yes, sir, it is.
Okay, thank you, Judge.
All right. Best of luck to you, sir. Thank you, ACDC.
You're welcome.
Michael Bateman. So do we have Mr. Jerome yet? No, not yet. What about Mr. Blevins? Let's see, do we have Freddie Caldwell? All right, Mr. Blevins, you ready?
Yes, Judge.
As position 5, Bostic 22 CP 214169, 97 days without indictment, no bond as of November the 23rd. Possession of cocaine with intent to distribute, possession of cocaine, VGCSA, possession of Schedule 1 or 2 with intent to distribute, possession, manufacture, distribution, sale of marijuana. We got 6.4 grams of coke, 15.3 grams of crack, 58 pills, and 48.5 grams of weed. Trial. And the other case was a decline to prosecute, Mr. Blevins. So this is the only one.
Yes,
Go ahead,
ma'am.
Bostic. Bostic.
I was talking. 13 prior arrests, very old trafficking. Prior cocaine with intent, 2012, purchase, manufacturing, sale, prior. Another cocaine with intent, manufacturing. Marijuana with intent, open case and top for trafficking and cocaine, 2 counts, Schedule 2. And controlled substance with the intent to distribute, 3 counts, nothing further.
All right, go ahead, Mr. Blevins.
Thank you, Judge. Mr. Caldwell is 54 years old. He's a lifelong resident of Atlanta. He has lived at the same address as most of his life, 210 Wadley Street in Atlanta, Georgia. The other case, position 6, was dismissed after preliminary hearing, where I believe this is going to affect this case is before your honor. We asked for a reasonable bond on it, Judge. The officer in that case, position 6, testified they did a control by Mr. Caldwell when he was in the Cobb County Jail, which led to the dismissal of that warrant. And he was arrested on a warrant on the second case. So we asked for a reasonable bond on the counts.
All right, go ahead, Ms. Broderick.
Your Honor, we are actually asking for 15,000 on each count based on the fact that this defendant actually has previous history of similar offenses, Your Honor. And there appears to be a Cobb County hold.
All right, no drugs unless prescribed, no alcohol, no weapons. You have an ankle monitor. Is he gonna live in Fulton County, Mr. Blevins?
Yes, ma'am.
All right, you got an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment. As long as you supply the name of your employer, proof of employment, a schedule, the exact location you're going to be working, sir. You'll have 48 hours to have that ankle monitor placed on your ankle since there's a hold. Once you get released that hold, 48 hours, sir, to have that placed on your ankle. Let's see. Right, 15, 10, 10, and 15. 15, 10, 10, and 15. Best of luck to you, sir. You can leave the booth. Thank you, Mr. Blevins.
Thank you, Judge. That's all I have. My big excuse.
Yes, sir.
Thank you.
So, Ms. Rhonda, do you know Thomas Holmes was indicted?
Yes, Your Honor, I'm aware.
Okay, just making sure. Okay.
Yes, thank you.
And we have Dennis Murphy here.
Yes, Judge. I got
Mr.
position
Murphy.
15.
Right. It looks like he is in Henry County.
It was my understanding, I've been in communication with the fiance that he was returned, that he's back in Fulton.
Well, they say he's not there.
Judge, I can just have a lieutenant check just to make sure. And does he have a location on where he was being housed in Fulton?
I'm not sure. I believe he was in Henry for several days. Let me look real quick. See, I had visited him several times there.
Okay, we're going to go to the next one. Let's see.
Judge, we'll just have the jail just check just to make sure why he's researching.
All right, what about Anthony Jones? Is Kyra Lynn here? Kyra Lynn. Kyra Lynn, turn the camera on. We'll come back when your lawyer gets back on. What about Shannon Hudson? All right, Ms. Rondon. That's position 1, Bostic 22 CP 213193. Shannon Hudson, 137 days without indictment, no bond as of October the 15th. Criminal damage to property, first degree, and simple battery. Pre-trial.
Judge, in regards to Mr. Hudson, multi-state offender, 20 in Georgia, arrest in Nevada and South Carolina, currently has a hold. 2017 controlled substance, currently on probation, 19 SC 166527, marijuana with intent, Schedule 4, firearm doing, firearm by. Schedule 1, also cocaine, sentence 9/20/12/19 for 5 years. Open case in
Yes, sir.
judicial hold with Judge Cox, 16 SC 142.
Henry County, we need to check on someone that the
The attorney's saying he's there.
Go ahead, Ms. Rondon, sorry.
Okay, sorry, was pretrial done?
You finished, Bostic, or did you just pause?
Pause. He has another open case, 23 SC 185795, aggravated assault, 2 counts, firearm during simple battery, firearm by. Nothing further.
All right, go ahead, Ms. Rondon.
Okay. Mr. Hudson is 32 years old. He is a lifelong resident of the Atlanta area. His entire family lives here, including his aunt, sister, and his 2 kids who are 4 years old and 1 year old. He does have a good address. That is 558 Plainville Drive Southwest here in Atlanta, where he would be able to live with his aunt, Tawana Hudson. He does receive disability checks due to medical issues and a previous gunshot wound. So we would be asking for a fairly low bond in this case because of his financial status. For the criminal damage to property first, we would be asking for $5,000, and for simple battery, we would be asking for $1,000. As Your Honor stated, Mr. Hudson has been in for over 90 days without indictment, and so he is entitled to bond at this point.
All right, what, Ms. Broderick?
Your Honor, the fact that the defendant also has other open cases, which include aggravated assault, and the fact that the victim in this case shares a child with the defendant. I believe there was a firearm that was involved. We believe that $50,000 for the simple battery because of the nature of their relationship, and $5,000 for the criminal damage are sufficient.
So the simple battery is a misdemeanor. It looks like it says he choked her. So, I mean, are you obviously going to change that?
Your Honor, that is a possibility once the case is indicted, that the allegations could be changed, but that the charges could be changed. But based on the fact that they have a relationship, they have a child together, he poses a significant risk to the victim. And so we just want to make sure that we don't have any issues of reoffending or intimidating the victim.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Monique, Monique, Upshaw, UPSHAW. Stay away from 1177 Joseph E. Boone Boulevard. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical, and employment. You have to supply the name of your employer, proof of employment, a schedule, and the exact location you're going to be working, sir. Yes, supply that to Ms. Rondon and to the ankle monitoring company.
And I'm sorry, Your Honor, did you say no further contact?
Yes, ma'am, I did. No further contact with Monique Upshaw. I'm just checking one thing here, see who.
Your Honor, may I say something about this case?
Okay.
We have the victim listed as a Jessica Weems.
Miss Weems is the alleged victim in the indicted case.
Okay, I just wanted to make sure.
Yeah,
Thank
that's what I
you.
was checking. That was a completely different case. All right, so I've got 15 on count one, and I think it's going to be upgraded, so 25,000 on count two. That ankle monitor be paid for by the county, sir. Best of luck to you, sir. You can leave the booth.
Hey, good afternoon, Your Honor. This is Carolyn. I'm sorry, I had technical problems, but I am ready.
All right, so Ms. Lynn, I'm not sure if we're gonna be able to hear you. You don't have a really great connection. So try it again.
Can you hear me, Judge?
Okay, yeah, we can hear you now. Anthony Jones?
Okay, is that better?
Yes, ma'am. Anthony Jones. All right, it's 22 Bostic 22 CP 213992. Anthony Jones, 98 days without indictment. It looks like pretrial came off of some of the charges, some on the bond on possession of cocaine, possession of MDMA, possession of marijuana less than an ounce, willful obstruction, misdemeanor, and driving without a license. There's already a bond that looks like second chance bail bonds. He's already posted that on the theft by receiving stolen property and the possession of firearm by a convicted felon. Pretrial.
Another open case, 22 CP 214179, firearm by a convicted felon, currently on 2 separate probation sentences on the same day, 17 SC 153797, 15 SC 172181. One is for burglary, MDMA. The other one is for robbery, firearm by prior conviction for armed robbery and robbery in 04. Nothing further.
All right. Go ahead, Miss Lynn. Do you have anything any different? Looks like second chance has not came off of those other two, correct?
That's my understanding, Judge. It just looks like the UJRs have been surrendered.
Okay, go ahead.
Yeah, thank you, Judge. So, Your Honor, Mr. Jones is a 39-year-old native of Atlanta, Georgia, Fulton County. He's a father of 3, 2 daughters, ages 17 and 19, and 1 son, unfortunately deceased, age 14. Judge, despite having not having education beyond the 3rd grade and having some very challenging circumstances during his childhood, Mr. Jones has maintained employment at the brick masonry, and also he works in commercial and real estate and residential real estate. He's done that off and on for the past 25 years. It does appear, Judge, as you've referenced, that Mr. Jones is in need of a bond on the controlled substance offenses on this case, the possession of cocaine, possession of MDMA, and he needs bond on the misdemeanors. I do want to bring to the court's attention that based on the warrants that I have, there's been no amount indicated for the controlled substance whatsoever. I think that's relevant as to the bond amount that Your Honor has the decision to make if you are willing to grant a bond. He also, Judge, has some medical issues that he's brought to my attention dealing with his kidneys. He has received treatment in the infirmary since he's been in custody since November 22nd at the Fulton County Jail. He has appointments with Grady coming up to deal with his kidney issues. And so we also ask that you take that into consideration on making a decision about bond so that he can receive the proper treatment. We are asking, Judge, that you allow the UJR bonds to be reinstated, seeing that he's been in custody on this case for 98 days with no bond, which is, again, beyond the 90-day rule. And Judge, he's also in custody on a second offense on case number 22 CP 214179. There is a bit of a discrepancy with his case, Judge, because he has me as private counsel on one case and then public defender on the other case, just because he has limited income being incarcerated. He is the primary breadwinner for his family. To my understanding, the case that the public defender is on the March 7th calendar. Since we're here, Judge, I didn't know if you wanted to consider that case as well. Mr. Jones would be very appreciative of that, or if you wanted for that case to remain on the March 7th calendar. But in terms of Ayala, Judge, he does meet the Ayala factors, in my opinion. He has ties to this community. He has 2 living children here, a sister here who he will be residing with if he's given bond. He has a girlfriend here as well, Judge. He has no ties to no other state. He does have some criminal history, as you heard. To my understanding, there's not an active probation on that burglary. That probation has not started. Mr. Jones is not under the impression that he's on the probation for the armed robbery either. I'd love to speak with the state about that. But he most certainly does not believe that he's on probation for the burglary offense. In addition, Judge, what I think is pertinent to this case is that there is a certified affidavit that's been provided to me. I provided it to the state, where the passenger in the vehicle is acknowledging ownership of the contraband and the firearm. She's actually logged on today if Your Honor wants to hear from her. And then on the other case that I mentioned, there's also an affidavit certified that's been presented that I provided to the state, where the owner of the firearm is acknowledging that it's their firearm. Mr. Jones just happened to be in the vehicle. He's had a streak of bad luck in these vehicles, Judge. He has limited education, as I stated. He's a primary breadwinner for his family. They're suffering tremendously, and so we would ask that you grant reasonable bond on this case, and if you would consider the other case while we're here.
Go ahead, Ms. Broderick.
Your Honor, in light of the medical information that was disclosed, we would actually defer to your wonderful expertise.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendant, Destiny Taylor. Stay away from all enterprise rental car facilities. No driving until you have a valid license, insurance, and registration. I know pretrial doesn't want a reinstatement back. So on the possession of cocaine, 1,000, MDMA, 1,000, 100 on marijuana less than an ounce, 100 on the willful obstruction, and 100 on driving without a valid license. He can make that, Ms. Glenn?
I believe so, Judge.
1,000, 1,000, and then 100 on the 3 misdemeanors.
And Judge, anything on the other case?
We don't have that on the calendar, but so I can't really take it up. Where is he going to be living? Is he going to be living in Atlanta?
Yes, Judge.
Okay. Is that on a prelim calendar or is it on my next bond calendar?
Judge, it's on the calendar for March the 7th.
Okay, yeah, since the state doesn't have notice, we can't take it up today. I'm sorry, Ms. Lynn, but I'll see you on March 7th. Or if you're in a prelim, we could take it up there.
No problem, Your Honor. I appreciate your consideration.
Have a good one.
Thank you. You do the same.
All right, let's see, Mr. Oliver.
Good afternoon, Your Honor.
All right, let's see, Brandon Richardson, wave your hand. All right, we got position 17, Bostic 22, CP 214012, 105 days without indictment, no bond as of November the 16th. Criminal damage to property, 2nd degree, and battery. Rah!
In regards to Mr. Richardson, 2 prior arrests, open case 22 CR 00609 4F, misdemeanor CWAT, criminal trespass, damage, terroristic threat, and battery. Nothing further.
All right. Go ahead, Mr. Oliver.
Your Honor, Mr. Richardson is a 27-year-old, a longtime Atlanta resident. Prior to his arrest, he was a first-year student at Atlanta Tech studying industrial engineering. He was employed with ResMed as a forklift operator, working 3 days a week as a 12 hours operating forklift. If released, he will live with his family at 126 Lion Road in Southwest Atlanta. He plans to be living there with his mother and father. He has 4 brothers and 2 sisters, all of which, with the exception of 2, live here in Atlanta. 123 days expired, Your Honor, between the alleged incident and the date that Mr. Richardson was arrested. I do not believe that the state will be able to provide any evidence that Mr. Richardson has been in contact with the victim. He runs no risk of intimidation to any witnesses. He's not a danger to the community, has no prior criminal history outside of the events surrounding the week preceding this particular incident.
Right. What says the state?
Your Honor, a victim's advocate from our office has spoken with the victim, and she has expressed fear should the defendant receive bond. Of course, we have to discuss it, but it should be noted that the victim has expressed fear, and we're actually asking for the battery, we're asking for $20,000, and for the criminal damage to property, another $20,000, Your Honor.
All right, 3 South, booth 3. Shut the door. Okay, so unless you're waiting on meds, stop going in and out. All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from all Starbucks, restaurant or stores, whatever they're called, coffee shops. Stay away from 3507 Camp Creek Parkway in East Point. No further contact with Imani, Imani, last name Pellisser. Gonna have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment. You have to provide proof of employment, name of employer, the exact location you'll be working. And sir, I'm actually going to go up a little bit on this, a little higher, because as of September the 10th, 2022, in case number 22 CR 006094, F as in Frank, there was a no further contact with this victim, and you violated those bond conditions.
Your Honor, may I add, he has not violated the conditions of the original bond. The original incident occurred on July 11th. This particular incident was July 16th. He was not arrested until September and November, respectively. So he has not violated the conditions of the original bond. He is under an $8,000 bond on that charge. And
I saw that. 20,000 criminal damage to property, 30,000 battery. Best of luck to you, sir. You can leave the booth.
Judge, can I provide you with an update as it relates to Mr. Rhodes?
Uh-huh.
The jail was able to locate him there at Fulton County Jail. Lieutenant Conklin said they're getting him in a booth. Okay, so he should be in a booth now. If you can let Mr. Dennis know.
All right,
He's in a booth now.
Okay, well,
I'm sorry, Your Honor, in regards to Mr. Richardson, you said no further contact with the victim. Can you also make sure that there's no further contact with her family?
No further contact with any family members of the victim?
Yes, Your Honor. The victim's concern was that the defendant made threats about killing her and her family during the course of these events.
Okay, we'll add that. Let's see. Do we have Michael Bateman? Michael Bateman. Wave your hand if you're Michael Bateman. Okay, there you go. Mr. Serge, you here?
Yes, Your Honor, I'm here for Mr. Bateman.
Okay, we got 13. 22 CP 214283, Michael Bateman, 94 days without indictment, no bond as of November the 29th, theft by shoplifting, criminal trespass. Pre-trial.
In regards to Mr. Bateman, 35 prior arrests, 4 arrests for probation violations, 4 FTAs, at least 6 felony convictions, couple of convictions, misdemeanor convictions for theft by shoplifting, felony theft by shoplifting, 3 open cases, 22 CP 214251, theft by shoplifting, 22 CP 208028, forgery in the first, 22 CR 001968C, theft by shoplifting, nothing further.
All right, go ahead, Mr. Jerome.
Your Honor, Mr. Bateman is 33 years old. He's a longtime resident of Atlanta. He doesn't have, obviously this is a theft case, but he doesn't know any of the victims in this case. He has no felony convictions. I heard pretrial give a lot of information here. From my understanding, he doesn't have any felony convictions, and he's not a significant risk to commit a felony. He has no history of violence or intimidation and doesn't know any of the victims in this case, and he is not a danger to the community. Mr. Bateman is currently sick. He's lost roughly 60 pounds since he's been incarcerated. He's been incarcerated since December, and we're just trying to get a reasonable bond on this.
All right, Ms. Broderick.
Your Honor, I believe there were several theft cases that have been discussed here. We actually believe that a reasonable bond amount would be $15,000 for the theft by shoplifting, and $5,000 for the criminal trespass, Your Honor.
And he's gonna live in Fulton County, Mr. Jerome?
Yes, he is, Your Honor.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from all Walmart stores. Stay away from 1105 Research Drive in Atlanta, Georgia. No further contact with your co-defendant, Michael Cox, COX.
Your Honor, it appears as if the defendant is trying to get your attention.
Okay, he may be living in, I want to say Rockdale with his mother and father.
I don't know what.
But I'm not 100% sure if it's Rockdale.
Okay, this is the only one we're handling, sir. You say he's got 3 charges. This is all I see on here, these 2.
No, I'm saying, I believe that he may be.
He's saying he has 3 charges.
Oh,
I'm
okay.
telling him the only thing I have on here is 2.
Oh, okay.
Are you gonna live in Rockdale County? Thumbs up or thumbs down? Thumbs up or thumbs down? Will you live in Rockdale? Okay. No further contact with Michael Cox. 10 on count 1 and 5 on count 2. Best of luck to you, sir. You can leave the booth.
All right. Thank you, Your Honor.
Thank you. All right, Kevon Harris.
Good afternoon, Your Honor. Attorney Andre Smith here. However, I think the public defender's office entered an appearance on this case as well, Your Honor.
Yes, Your Honor. Kevin Anderson from the Public Defender's Office.
So, Ms. Broderick, are you handling this or is this for someone else?
What number is that, Your Honor?
Position 18.
I believe I am the only one here.
Okay. All right, it's 18. So we got 106 days without indictment. There is a $146,000 good bond as of November the 17th, 2022. Entering an automobile. Okay, let me see. This is going to be, it's kind of entering an automobile or motor vehicle with intent to commit a felony, possession of tools for the commission of a crime, theft by receiving stolen property, theft by taking misdemeanor, willful obstruction misdemeanor, entering an auto or motor vehicle with intent to commit a theft or a felony, entering an auto with a or motor vehicle with intent to commit a theft or felony, entering auto with a motor vehicle with intent to commit a theft or felony, entering auto or motor vehicle with intent to commit a theft or a felony, entering auto with a or motor vehicle with intent to commit a theft or a felony, entering auto, 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 all with intent to commit a theft or a felony. Then unlawful for a person and be employed by or associated with criminal street gang or participate or conduct criminal street gang activity. Times 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. And this bond was set very low and by a judge that was not me, but go ahead, preach, Rob.
Judge, in regards to Mr. Harris, 2 prior arrests, open case 22 CR 00402 OC, pistol, a revolver, and misdemeanor possession. Nothing further.
Go ahead. Who's going to do this, Mr. Anderson? You?
Oh, I'm not sure, Your Honor. I think there's a little confusion. Mr. Smith this was initially with our office. Apparently, Mr. Harris's father.
Rock, paper, scissors, do something. Let's go.
Well, I filed a bond motion back in December, so I'll go for it, Your Honor. Your Honor, this is a young man who is in the 12th grade. Obviously, this case has derailed him from being on track to graduate this year from high school. He is his father is on his behalf and in support of him. Your Honor, when he first went into jail back in November, there was an $80,000 bond on him. I think he subsequently went to court 3 more times within the span of a week, and the bond had ballooned to up to $146,000. In speaking with his family, his father and his mother, I do not believe they have the means, Your Honor, to make a bond of this amount. While the 8th Amendment does not say that the bond has to be reasonable, I think it's tantamount to no bond when it comes to my client, Your Honor. Your Honor, he would live in Fulton County with his mother, and he's resided here his whole life. Um, he, uh, he's not opposed to any ankle monitor or curfew if he was to get out on a lower bond. Like I said, he was a senior. He is a senior in high school, but that has been derailed because of this case. I have no knowledge whatsoever of any convictions that he has. I think the other case is a misdemeanor case that is still pending, that has not been resolved. He does work for and has worked for a record label and does make music as one of his hobbies and one of his jobs that he makes money on. Your Honor, I don't see him as a flight risk. I see him returning to court. He has an attorney. He has all the ties in the community. I think that, again, the bond is extremely high from the bond that he went in on, which was $80,000. I'm asking this court to reduce this bond for this very young teenager and young man who doesn't have any criminal convictions whatsoever at this time to $50,000. I know that's a bond that the family can make. I understand the court might have some reservations, but I don't think the $146,000 as in regards to my client is a bond that he could make and is tantamount to no bond in this situation.
Go ahead, Ms. Broderick.
Your Honor, as you were reading, of course, you see how many charges are here.
38.
All in close proximity the same day, Your Honor. The purpose of the bond is to make sure that we are making sure that there are no additional, one of the main things is that there's no risk of committing any felony while a trial is pending. The fact that all of these offenses, the alleged offenses, were all committed on the same day. And I believe the defendant was in possession of a firearm at the time that he was arrested. We believe that the $146,000 based on the nature and the amount of the offenses is reasonable, Your Honor.
And Your Honor, to piggyback on that, I do not believe that my client was actually caught in actual possession of a firearm. I think it's a situation where it was multiple people that got charged, and he was one of those people that got charged. However, I don't believe that he was in actual possession of it. This case is really going to boil down to a situation of whether or not Mr. Harris was in association with these others that has not been proven. Of course, he's innocent of proven guilty, but again, the charges he initially went to jail on, it just kept adding up as he was in jail. It was not if he bonded out and committed more crimes. It was just more charges kept coming as he sat in jail. So once again, when it went from $80,000 to $146,000, that just made it tantamount to no bond for this young teenager. So I'm asking the court to have mercy on my client and reduce the bond down to a reasonable amount to where his family will be able to aid in his defense and get his GED and move forward in life as he deals with these charges.
Well, like I said, I can tell that I'm not the one that set this because I wouldn't have set $2,000 a piece for every gang charge. That's usually $100,000 plus on all the gang charges per charge. So no drugs unless prescribed, no alcohol, no weapons, and no replicas of weapons, no social media whatsoever, no further contact with anybody associated with PH, Paid Hustlers is the name of this alleged gang. Any members or affiliates or any other gang members in the United States of America, especially in the city of Atlanta. No further contact with, and Ms. Holmes, this is all on the previous bond order for these names. Therese, Terese, Atkins, Roach, ROCH, Elijah Barrington. No further contact with ALASSANE, last name KONATE. No further contact with Aaliyah Newton, Patricia King, Shalom Nicholas, anyone at PV Holding Corp, Melissa Swint, Jeremy Swint, Devon, last name GHOLSON, then DeMarco Montreal Smith, Eddie Jones, Kaya Patterson, Jadea, JENDAYA Williams, Lauren Allen, TUNJI, last name ADEBAYO, Zachary Durr, DURR, Patrick, last name ONIMOLE. Stay away from 641 Formalt Street. Stay away from 585 Wells Street in Atlanta, Georgia. No drugs, no alcohol, no weapons. Going to have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and school. You have to supply proof of enrollment and proof of participation, the exact location you're going to be working. Sir, I mean, you're going to be going to school. Sir, that doesn't mean you leave school and go to McDonald's for 4 hours. You go straight to school, you go straight home. There's no other reason for you to leave your house. I'm going to reduce count 1 to 30,000. I'll reduce count 2 to 2,000. I'll reduce count 3 to 5,000, count 4 to 5,000. I'm leaving the rest of them as they are. So that's 30,000, 2,000, 5,000, 5,000. And these other ones, please, Ms. Holmes, note that this was set by another judge and not me. 5,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000, 2,000. Well, I'll make this easier. 2,000 on all the remaining counts. Like I said, once again, on the drug chart, on the gang-related cases, they wouldn't have been 2,000 by me. They'd have been 100,000 plus per count. Best of luck to you, sir. You can leave the booth.
Your Honor, do we know what the total amount is at this point with the new reduction?
So I just rattled all those off. So 30,000, 2,000, 5,000, 5,000, 5,000. All the rest of them are 2,000 up to 38 counts. So okay. I guess you could try to do that math. I
didn't go to school for math, but I'll do my best, Your Honor. Thank you so much.
I reduced it about 40,000. Thank you. She'll have it e-filed shortly.
Okay, thank you so much, Your Honor.
Thanks, sir. You can leave the booth.
Okay, thank you.
Giante McGee. Ms. Rondon. All right, this is position 20, Bostic 22, CP 208850, 299 days without indictment, $15,000 good bond as of May the 6th. For theft by receiving stolen property. Once again, I am not the judge that set this bond. Unlawful for a person employed by, associated with criminal street gang to participate in criminal street gang activity. ×2, willful obstruction and possession of a firearm during the commission of a felony. Pre-trial.
Mr. McGee, open case 23 SC 1861228, 8 counts of entering auto. Recently took a first offender plea in Douglas for entering auto 5/10/22, 15 months confinement, 3 years, 3 months probation. Nothing further.
All right, Ms. Rhonda.
Mr. McGahee is 20 years old. He is born and raised here in Atlanta, where the majority of his family lives. That includes his one child, a 1-year-old son. He does have a good address on file, which is the old National Highway address, where he would be able to live with his grandmother, Miss Easley. Before being incarcerated, he made it to the 10th grade at Skyview High School. But while at Rice Street, he has enrolled into the GED program and has made substantial steps in completing the program. He is actually up to take the test to pass and get his GED. He can continue the program on the outside. In addition to the GED program, he has also taken and completed the following classes, receiving certificates: the Matrix class, the Thinking for a Change class, and the Life Skills class. Prior to being incarcerated, he was also doing landscaping with a landscaping business owned by one of his friends, and he would absolutely be able to go back to that work. We are asking for a reduction in bond this evening. We would be asking for count 1 to be reduced to 1,000, count 4 to be reduced to 1,000, and count 5 to be reduced to 2,000, and counts 2 and 3 can remain untouched.
What's it, Ms. Broderick?
Your Honor, we actually believe 15,000 is extremely reasonable. And we ask that it remain the same, Your Honor.
Once again, Ms. Holmes, make sure we note on there that I am not the one that set these gang charge bonds, because these are $2,500, which is absolutely ridiculous as far as I'm concerned. However, no drugs unless prescribed, no alcohol, no weapons, no further contact with Jeffrey, Jeffery, last name White. Oh, also no replicas of weapons, no further contact with your co-defendants. RONISIER Jones Davis and JAQUEZHORNE. And there was also, I don't know if this was a misspelling, hold on. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. Any other reason he needs to leave? School?
Possibly school, yes, for the GED program.
Right. School for his GED program, but he has to provide proof of enrollment and proof that he's going. No social media. No further contact with any members of any gangs or any affiliates of any gangs, and especially the Slime Gang Young crew. Young, for some reason, it's spelled YUNG, crew, CREW. Young Slime Gang Young crew. Excuse me, it's 5275. Slime Gang Young crew. No further contact with anyone there or any other gangs. No social media. Like I said, I made some changes, so I'll reduce count 1 to 1,200. I'm leaving 2 and 3 the same, 2,500 apiece. Count 4, 2,000. Count 5, 4,000. 1,200, 2,500, 2,500, 2,000, and 4,000. Best of luck to you, sir. That ankle monitor will be paid for by the county. Please put that I'm not the one that set those gang bonds on there. That makes sure when it's first on 5, only on 2, and live at 11, they use the right judge's name and not mine.
Yes, Judge.
Thank you, Your Honor.
Thank you. All right, Mr. Partridge, you got Tavarius Williams. Thank you, Ms. Rondon. I think that's it for you, right?
No, Your Honor, I have
yeah.
one case on the bond modification calendar.
Oh, okay. All right, Mr. Partridge, this is position 10, Bostic 22, CP 209034. Tavarius Chavez Williams, 292 days without indictment. There is a $460,000 split bond as of November the 7th, 2022. Possession of firearm by a convicted felon, VGCSA, possession of methamphetamine with intent to distribute, VGCSA, possession of Schedule 1 or 2 with intent to distribute, possession of cocaine with intent to distribute, trafficking in heroin, possession of controlled substance of Schedule 1 or 2 with intent to distribute, possession of controlled substance Schedule 1 or 2 with intent to distribute, theft by received or stolen property, possession of a firearm during the commission of a felony, and possession of marijuana less than an ounce. Pre-trial.
15 prior arrests. Open case 22 SC 184241, theft by receiving stolen property. Possession of an altered VIN. Prior convictions, a prior ag assault, aggravated battery, firearm during burglary, a criminal damage to property, theft by receiving, prior robbery convictions, 2 misdemeanor, 1 arrest for probation violation. Nothing further.
All right, go ahead, Mr. Partridge.
Thank you, Judge. Judge, Mr. Williams has been before this court on 2 previous occasions regarding bond. Back in November, the court did set a bond, a very high bond, that my client has not been able to meet or make at this time, Your Honor. So we're asking the court to consider a reduction as to the bond. Judge, you heard that Mr. Williams does have some things on his record. However, Judge, I'd like to provide explanation as it relates to that, as well as the open case that we have in Fulton County. Mr. Williams does have former convictions. He was on probation at one point as it relates to those convictions. When he was arrested for this situation, Judge, his probation was closed out. And the reason why it was not revoked was because the other case that we have here, which I'll get into, is a very weak case, doesn't make sense, but nonetheless, he was charged as it relates to this. And this case is a very similar situation as well. That case that is indicted, Judge, as it relates to an altered VIN and a possession of a vehicle, stolen property. In that situation, Judge, Mr. Williams was a passenger of a vehicle that was not his, was not registered to him. He was a mere passenger. I just received discovery on that case last week, and I've been able to read through it. And I'm not sure why the state indicted it, but they did. So we'll fight that case as we get to that. Not a problem, but Mr. Williams had nothing to do. He was a mere passenger in that vehicle, but nonetheless, the arrest warrant was placed on him. Judge, as it relates to his priors, we're talking priors that are from over 10 years ago at this point. Mr. Williams served his time in custody. He served his time on probation, Judge, did not have any probation violations, with the exception of being arrested here in this situation. He successfully completed over 11 years of probation, Judge, without a violation until coming here. With this particular incident, Your Honor, similar situation. Mr. Williams was in a park or at a park, not inside of a vehicle where all of the contraband that the court read off was found, as well as firearms. There was nothing, absolutely nothing on Mr. Williams's person. Judge, it's my understanding that there was a car key that was found in the back of a police vehicle that Mr. Williams, as well as a co-defendant that was arrested, it was found in between the two of them. It is our position that that key belonged to not to Mr. Williams, but the co-defendant, Your Honor, and that Mr. Williams he didn't have anything to do with the car. There's no evidence that suggests that a vehicle was registered to Mr. Williams on that day. In fact, Your Honor, Mr. Williams was leaving work and had just arrived to the park. He has, and I've told the court this before, he has a clothing line and he was bringing clothing to share with some friends at the park, and he was leaving. He had just left work. Judge, Mr. Williams is 36 years old. He does have 7 children, 6 boys, 1 girl. He does have custody of his 12-year-old that he's not seen or been able to parent in almost a year at this point. Judge, we're asking the court to set a reasonable bond. He does have an opportunity to go back to work. His stepfather owns a construction company in which Mr. Williams has worked for and has a job currently if he is released. He lives in the DeKalb County, Decatur area, so would have no reason to be in Fulton County unless it were for work. He has no issue with an ankle monitor. If the court wants to impose any type of curfew as it relates to Mr. Williams, he's fine with that as well, Judge. We're just looking for an opportunity for him to get out. This case is almost a year old, and it has not been indicted. I'm not sure the reasons why it has not been indicted, but there's another case that Mr. Williams was arrested for at the same time. That case was indicted. This one, ironically, was not. So, Judge, I understand the state has a statute of limitations to indict a case, not rushing them to do that. If they see fit, great. We'll be ready to challenge the case at that time. But at this point, it's not indicted. Mr. Williams, I believe, would be a good candidate for bond, Judge. He's not a flight risk at all. He does reside with his mother as well as stepfather in that Decatur residence. He has a number of family members that are in the area, as well as friends and concerned other family members, Judge, as well, that will make sure that he is appearing in court and staying on track and doing the right thing. In fact, when he's on probation, Judge, during this situation, Mr. Williams would have pop-up visits from the probation officer as it relates to his probation, Judge, because one of those former offenses had to do with firearms. So Mr. Williams would not be around firearms whatsoever. His stepfather and mother have done away with their firearms so that he could live there without any violation. So he's gone over and above, Judge, to stay on the right track and stay on the straight and narrow, and was very close to being released from probation at the time that he was arrested in this situation, Judge. So there's no way that Mr. Williams would want to violate his probation and being in this situation. Your Honor, we're asking the court to consider a reduction of the bond to $90,000 as follows. Count 1, Judge, we'd ask to be reduced to $5,000. Count 2 to $10,000. Count 3, $10,000. Count 4, $10,000. Count 5, $25,000. Count 6, $10,000. Count 7, $10,000. Count 8, $5,000. Count 9, $5,000, and count 10 to remain a UJR, Judge. Thank you.
All right. Ms. Broderick?
Your Honor, we actually believe that the bond that was set was appropriate and that it should stay the same, and we defer to your recommendation, Your Honor.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 447 Wabash Avenue in Atlanta, Georgia. No further contact your co-defendants. Keith Troop, T-R-O-U-P. I'll spell this other name. R-A-K-E-Y-S-H-E-A-Y-E-E. Last name Benz, B-E-N-N-S. DeMarcus Jenkins, all co-defendants. State of Fulton County, let you hear for attorney defendants, court, and work. You have to supply the name of your employer, proof of employment, a schedule, the exact location you'll be working. ankle monitor be paid for by the county with that 24-hour curfew. And Mr. Barters, I'm sending emails to the Madam DA every night with anything that's over like 250 days without indictment. So I'll be glad to include this one on there.
Thank you, Judge.
Count 1, 10,000, count 2, 20,000, count 3, 20,000, count 4, 10,000, count 5, 75,000, count 6, 20,000, count 7, 20,000, count 8, 20,000, count 9, 20,000, and count 10, UJR through the jail. Best of luck to you, sir. Stay out of Fulton County.
Thank you, Your Honor.
All right, have a good one.
You too, Judge.
William Rhodes. William Rhodes, wave your hand. All right. So I got two, it's position 15, Bostic 22 CP 214079, 102 days without indictment, no bond as of November the 19th. Criminal damage to property in second degree, burglary in the second degree, possession of tools for a crime. Brief. Wow.
11 prior arrests, currently on probation in Coweta for theft by taking and tools, sentenced 10/25/22 for 10 years. Open cases in Clayton, theft by taking, criminal damage to property, criminal trespass, and hearing, criminal damage to property, theft by taking. Nothing further.
Go ahead, Mr. Murphy.
Judge, my client contends the only open case is in Henry County. I've got that he's been in custody 104 days total, no bond. He's age 49. He's a lifelong resident of Atlanta. He lives at 2960 Harlan Drive in East Point, 30344 with his fiance, Cindy Bryce. Judge, I'm asking for a reasonable bond under the circumstances. I think factually this is maybe criminal trespass. If anything, the alleged location of this incident is 1286 Millage Street, and it's described in the narrative as direct import warehouse. That's in fact a vacant warehouse. It has no doors, it has no windows, it has no locks. Importantly is that one of the co-defendants is a woman by the name of Patricia Sanders, who is his mother. My client contends he was there under an apparent authority to for an industrial salvage, and that was the purpose he was there for. Which there's no sign of an allegation of a broken fence, but however, in the narrative, Miss Sanders's car is at the location inside the warehouse. So I cannot see how the car drove through a fence or anything therein that my client that's consistent with my client's contention that he had the apparent authority to be there. My client again has stated that this is, and I've looked into this, is an abandoned warehouse. My client is employed as a tree removal specialist with a gentleman by the name of Chad Whitmer, who's out of Hapeville, Georgia. But again, he's a lifelong resident of Georgia. He will stay in Fulton County. And I've advised him on my meetings with him that if the court will grant him a reasonable bond, that he will stay to his landscaping tree removal trade and not venture off into any other occupations for the safety of all involved and for the assurance of the court. So I'd ask for a reasonable bond, Judge. I would, in terms of this alleged burglary tools, that the narrative does not say who the tools were found on, that the tools were found in a general area. These were electric saws, hardly anything that could be used in a clandestine way. Again, I'd ask for $2,000 on the first count, $2,000 on the second, $1,000 on the last count, Your Honor. Reasonable bond. Again, he'll honor all the conditions of the court, and he will return as a tree removal specialist, nothing additional along those lines, and he will follow the court's directives as required. Thank you, Your Honor.
Ms. Broderick.
Your Honor, without getting into the facts at issue, we actually defer to your guidance.
They'll give me some numbers.
When Gabe Banks ran, he said, I was going, dude, you gonna cash that?
Your Honor, 5,000 for each count, please.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 1286 Millage Street in East Point, direct import warehouse. Whether it's empty, no doors, no fence, no nothing. Stay out of there. The copper that's there needs to stay there. You have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, and employment. Provide proof of employment, name of your employer, scheduled, exact location you'll be working. Provide that to the ankle monitoring company and to you. 5,000 on count 1, 5,000 on count 2, and 2,000 on count 3. 5, 5, and 2. Best of luck to you, sir. You can leave the booth. Thank you, Mr. Murphy. All right, Christopher Ford. Right, it's 7, Bostic. 22 CP 208808, Christopher Ford, 300 days without indictment, entering auto with the intent to commit a theft or a felony. Theft by taking, loitering and prowling, possession of a pistol or revolver by a person under 18 years of age. As of May the 6th, there is a $13,000 good bond. Wow.
3 prior arrests, no conviction, open case in DeKalb for entering auto, nothing further.
All right, go ahead, Mr. Olive.
I thank you, Judge. Excuse me. Mr. Ford moved to Georgia in 2021. He does have several sisters here and a brother. His mother, he moved here with, she had to go back to Florida with some serious health concerns. And she's being treated. She went back to Florida because she could receive better treatment there, but she plans to return to Georgia once she's back into the condition where she can return. I'm sorry, Mr. Ford is he's spoke to me. He's very interested in going to a GED program, so we would certainly consent to that being a condition of the bond. If you were to lower the bond, if he were to get out, he would also be staying with a probation officer, and Your Honor would be happy to know that that will be in DeKalb County in Lithonia. Again, I'm really trying to, another point I'd like to make, Judge, is that he's been in there for, a while now, about 9 months or so. And I'm sure this court knows as well as anybody how these young men get sucked into all that nonsense that happens in the jail. And he's managed to stay out of trouble that entire time. So I think that's a pretty good indication of him trying to do the right thing and stay that way. He's got his family behind him, trying to support him. He does have a bond, but he couldn't afford to bond out, Judge. So I would ask again and we would also consent to an ankle monitor and, curfews, the whole 9 yards, if it pleases the court. Thank you, Judge.
All right, I'll include this name also on that email to Madam DA. What says Ms. Broderick?
Your Honor, this bond is actually very reasonable considering the age of the offender, and we are asking that you leave it the same. And the victim in the case has expressed to our victim advocate that they oppose the bond.
Which victim is that? I got a whole bunch of them.
From what I know, I just have that bond is opposed. I don't know which victim they're talking about.
Okay. So he's been in 300 days without indictment. So let's see. No further contact with Lalina, Lalina Faust, Foust, Charles Hurley, Hurley, Janae, Janae, Danielle Collins, Collins, Ezekiel, Ezekial, Blaylock, Blalock. Next one is Adwoa. Kufor, Kufor, Asante McPherson, Assante McPherson, and Robin Rybyn Kathy, Cathey. Stay away from 144 Moreland Avenue. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the county with a 24-hour curfew. You can leave for court, lawyer, medical, or to work on your GED. You have to supply proof of enrollment, the exact location you'll be taking the classes, and you have to turn over that schedule to your lawyer and to the ankle monitoring company. Sir, you're going to stay out of Fulton County unless you're here for court or to see your lawyer. Don't stop for gas. Don't get a flat tire. Don't come to Fulton County except court or to see your lawyer. Absolutely. Stay in DeKalb County or anywhere else. Let's see. 3,000 on count 1, 2,000 count 3, 250 on $250 on count 3. Excuse me. 3,000, 2,000, 250, and 3,000. 3,000, 2,000, 250, and 3,000. Best of luck to you, sir. You can leave the booth.
Thank you, Judge.
All right. And I will include that name for you. All right. Let's see. We got Terrence Jones. All right, Mr. Butterfield. I think I saw you here somewhere. There we go.
Good evening, Your Honor. That's Terrence Johnson. We are ready to proceed on that matter, Judge.
All right, that's number 2, boss. They're going to add on 22 CP 213-811 Terrence Johnson, 112 days without indictment, There is a $15,000 split bond as of December the 15th, 2022. Ag assault, possession of firearm or knife during the commission of or attempt to commit certain felonies. Pre-trial.
And I'd like to see Miss Boston's face, Your Honor. I hadn't seen her in a long time.
She doesn't look any better, Mr. Butterfield. Same old mean old crusty Boston.
No, I beg to differ, Judge, but if she
crab.
doesn't want to appear, I understand.
Judge, 14 prior arrests, 2 misdemeanor convictions, 22 CR open case, 002085 battery, reckless conduct, misdemeanor possession for someone under the age, open case in Douglas for aggravated assault, aggravated battery, and theft by taking. Nothing further.
All right, go ahead, Mr. Butterfield.
Your Honor, we here today because Mr. Johnson, unlike when we first appeared before the court in December, he's now been incarcerated for over 90 days. I believe he's 110 days or something of that nature. He's been in, I believe, since November the 8th. So we asked that a bond be set based on a 90-day rule. Your Honor heard a lot in this particular case. If you recall, Judge, I sent Your Honor videos and text messages from the listed complaining witness in this matter, and your honor encouraged that I share that with the state, which we did prior to the bond hearing. And I would like to say that the court was almost inclined to grant bond, but did not that night. Judge, a little bit about Mr. Johnson, and I'll get into the facts. As the court may recall, he's 22 years of age, has no prior felony convictions, although he has the pending case in state court before Judge Richardson went representing him. And he had the case in Cobb that they're reducing to a misdemeanor. And then he had the matters that Mr. Bodie was handling in Douglas. That's all on the pretrial report. But he's 22. He is a senior in college at Georgia State with only 2 semesters left. And we spoke with the court about that matter. I just sent to Your Honor, as well as Ms. Trevoria. I did not have the current prosecutor's email. I would have emailed to her, but he has currently received an internship, Judge, with
it's okay
Mar.
for.
Go ahead. That's Miss Rockwell. Miss Rockwell, stay on mute. Go ahead, Mr. Butterfield.
Okay, it's called Mar. Mar. It's called Mar Global Group, Your Honor, and he works in the his degree is going to be in the music industry, and he, as the court may remember, is an up and coming artist. This internship will require that he travel and set up meetings with companies. So we do have that. I want to tell the court he is in school, has an internship. We sent the court as well as Ms. Trevoria a copy of that internship. If released when released on bond, Judge, he will be leaving with his mother at 995 Forest Overlook Trail Southwest in Atlanta, Georgia, 30331. And again, no prior felony convictions. Let me just tell you a little bit about this case as you consider the bond. And I'll tell you, bottom line, Judge, we're going to ask that you do around 10,000 or less, that he have no contact with the listed complaining witness, that's Miss Raven. I won't put her full name on there. That he actually have no weapons, no illegal drugs or anything of that nature as part of his bond. Now, Judge, since we left Your Honor, we had a preliminary hearing in this matter with Mr. Trapanier, who was the prosecutor. Witnesses were called back on January 31st, 2023. And Judge Dallas mentioned that in her mind, although she found probable cause, this was a very flimsy case. And I'll just tell the court the facts. In this case, Judge, if you look at the warrant, it's alleged that Mr. Johnson kicked in the door, choked the complaining witness, and that he pulled the gun. Well, there was no evidence when they went in about damage to a broken door, in the sense of no damage to the hinges and locks or anything like that. There was no physical injuries that they listed to the complaining witness. That's what officers said. He did not charge battery at all. He charged the ag assault based on the allegation about a gun being pulled. In this particular case, there was no description of the gun. Like, it wasn't, it was a big black gun or a silver gun. It was just, he pulled a gun allegedly. In this particular case, Judge, they went back, the investigator went back to speak with the complaining witness, and they have not spoken with her. She was not at the prelim. I don't know if this prosecutor or the victim witnesses have even located her, but that indicates our belief in this case that this was about a scorned lover. The text message that we sent, Your Honor, on the very same day the allegations were made, there were the text messages that going back and forth between the complaining witness and Mr. Johnson. She had seen him performing at a club and saw him with some other girl, and that was the gist of it. But just within a matter of days or hours, she was right back with them with videos that we provided to the court saying that, you know, she was with him and all the other females should step off. That was September. We've never heard back from this young woman, but that is what we have, Judge. So, you know, he maintains that his innocence and seeks to vindicate himself at trial. So we're asking for a low bond, Judge, even though the allegation, anytime somebody is accused of an ag assault, it's a serious allegation, but the facts surrounding it are very flimsy, Judge. So we would ask that you set the reasonable bond around $10,000 with the proper terms and conditions that he could meet, where he could finish school and be able to travel with this internship that's confirmed, Your Honor.
All right, what says the state?
Well, first, Your Honor, I would like to let the court know that the victim is actually on this Zoom. She tried to log in and wasn't able to, so she's actually listening with the victim advocate. I'm not going to get into the facts of what happened because that's not what we're here for. Based on, obviously, there was something there that allowed him to be arrested. So it's not a situation where, you know, we're arguing that nothing happened. But in terms of how far we go with talking about the allegations, we're just trying to make sure that, you know, the defendant appears when he's called to come into court. And based on these allegations that have been made and the fact that the victim is on the call now, we think $120,000 is reasonable. I did receive the court's email concerning the internship. I've heard that the defendant is being asked or would like to travel. I'm not sure if that's supposed to be out of the state or not. I'm not sure what the travel means. But that also gives us pause under these circumstances, Your Honor, if he has the ability to come and go from the state, whether or not we're going to have, you know, him reappear when necessary. And so we would ask that you grant a bond of $120,000, Your Honor.
And if I may just speak to the travel,
Okay.
Judge, anything with regards to the internship would be, you know, taken care of by Georgia State. So, you know, he does not have the ability to make a $120,000 bond. He lives with his mother. He is a student, so he doesn't have the ability to make that. That'll be like no bond at all. And the statute calls for a reasonable bond to be set. So, you know, I've heard. Last time and this time, every case is different, but he didn't shoot anybody like some of these folks and everything else. And I know earlier I heard an ag assault case had a $10,000 bond, but this case, Judge, based on the facts that we have and the evidence, we would definitely say $120,000 bond leaves him sitting in jail.
Right. No drugs unless prescribed, no alcohol, no weapons. You got an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical, and school. As long as you supply proof of enrollment, your schedule, the exact location you're going to be going to school, you have to provide that to your attorney and to the ankle monitoring company. Stay away from 400 Far Road Northeast in Atlanta, Georgia. No further contact with Raven Neal, Neal. If there's any kind of hold, you have 48 hours to have that ankle monitor placed back on your ankle. And he's gonna live in Fulton County, you said?
Yes, Your Honor. He born and raised.
All right. 25,000 count one, 15 count two. Best of luck to you, sir. You can leave the booth.
And Your Honor, does that allow for him to leave the state?
No, I mean, if he's gonna have to go anywhere, he's gonna have to file a motion to get permission to go anywhere.
Thank you, Your Honor.
All right. Thank you, Mr. Butterfield.
Thank you, Your Honor. Judge, that concludes my business with the court. May I be excused, Judge?
Yes, have a good one.
Thank you, Judge.
All right, Terrence Parks. All right, it's the number one on the add-on, Bostic 22 CP 210375, Terrence Parks. All right, so it's not on this one, but it's 1,735 days without indictment, but not necessarily on this case. It's on another one. Aggravated battery, aggravated assault with a deadly weapon, no bond as of July the 4th. Free! Rah!
Judge, 19 prior arrests, 3 arrests for probation violations, 2 misdemeanors, 2017 robbery. Judge, he's taken a plea on the case that brought him into custody. 18 SC 161451, a CWAC case, sentence 9/13/2022, 7 years confinement, 8 years probation, nothing further.
I think, Mr. Olaf, that's where he got time served on that. That's where it's got the 1,735 days.
Yes, Judge.
Okay, go ahead.
Thank you, Judge. Read right over here, sorry. Now, Mr. Parks has lived here in Georgia his entire life. His entire family lives here. The address on file is a good address. He can stay there with his mother if he is released. He too is interested in working on his GED program when he gets out. And as you pointed out, Judge, it's been over 3 years that he's been incarcerated. As you mentioned, not for this case, but still he's been there for a long time. And in this instance, we would ask, he obviously doesn't have any money since he's been in jail for so long. So we would just ask for a reasonable bond in this matter, Judge. Thank you.
All right. Go ahead, Ms. Broderick.
Yeah, we are actually asking for $25,000 for the aggravated assault. And with the aggravated battery, we're asking for $50,000. The allegations are that another person was stabbed in the back, head, and neck, I believe. So we're concerned about the ability or the defendant's willingness to abide by the laws. I think he was in custody. This was a jail incident, so he was in custody at the time that this happened. And so we believe that there's a high likelihood that the defendant would reoffend, Your Honor.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Vernon Young. Have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and school for the purposes of GED. You have to submit proof of enrollment and the exact location you're going to be taking classes, sir. And I'm not sure if this alleged victim, Vernon Young, is still in custody. However, 20,000 on aggravated battery, 25,000 on aggravated assault. Best of luck to you, sir. That ankle monitor be paid for by the county.
Thank you, Judge. And that's my last client for the day.
Yes, sir. Have a good one. Let's see.
I
We
do
got
the same.
all right. We got some motions to modify, but here's our last one. Javon Spencer.
I'm sorry, it looked like somebody was trying to get your attention. I'm not sure if that's the defendant from the previous, Mr. Parks is, I think that's him
I think
waiting.
that's a defendant from the previous, but I'm sure his lawyer doesn't want him to say anything. All right, position 19, Bostic 22 CP 207702. 1,097 days without indictment, aggravated assault, no bond as of March the 24th. And I believe the 1,097 days is not because of this, it's because of another issue. This is aggravated assault. Preach. Rah.
Judge, in regards to Mr. Spencer in custody, 20 SC 177090 for aggravated assault with a deadly weapon, 2 counts.
Okay, this guy hadn't been indicted.
Go ahead, Boston.
Firearm during capital offense, felony capital offense, 3 counts in hijacking. Signed to Judge Barwick. Nothing further.
All right. Go ahead, Mr. Law.
Mr. Spencer is age 22. He's lived in Atlanta his entire life with all of his family. He completed school in 2018 through an online school for his degree. Before he was arrested, he was moving pool tables with the Affordable Billiards Company and doing other odd jobs. He volunteers at his niece's school to help out the classes with school parties and things like that. The address on file is correct, which is in Macon, Georgia, so it's outside of Fulton County. And And he does have a medical issue exacerbated in the jail. It's asthma. And he has trouble getting an inhaler while inside the jail. So we are asking for a reasonable bond to be set in this case. He is in no bond status at this moment, not to exceed 30,000.
All right. What says the state?
Your Honor, based on the fact that he's currently in custody for serious offenses, felony murder, I think when this offense took place, we believe $400,000 is sufficient.
And I'm pretty sure he's not going to get out. No drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendants, Leroy Pitts, Pitts, Quantavious Ray, RAWY, no further contact with DeMarcus Dewberry, DEWBERRY. If and when you were to get out, you have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical. Mr. Lyle, this has him living in Macon on his booking sheet. Is that correct?
Yes, that's his father's address.
All right. Here he'd stay out of Fulton County unless he's here for court or to see his lawyer. Don't stop gas, don't get a flat tire, don't do anything. Straight from Macon, straight up here if you happen to get out, sir. $200,000, good bond. Best of luck to you, sir. You can leave the booth.
And that is my final case. Might be excused.
Yes, sir. All right, so now we got some bond modifications. All right, let's see. Do we have Ms. Rondon? We got Donnell Hacker. Mr. Hacker, if you're here, turn your camera on. Don't see your client. All right, Donnell
Mr. Hacker.
There he is. Mr. Hacker, you got to turn your camera on. Mr. Hacker, you have to turn your camera on.
I'm gonna give him a call really quick, see if he's.
There he is. Mr. Hacker, you've got on a tank top. Not appropriate. Put on a shirt with some sleeves. All right, here we go. It's number 4 on the bond modification, Bostic. It's 21CP 1977729. Donnell Ishmael Hacker. He is out on a $40,000 bond, kidnapping, simple battery, and cruelty in the 3rd degree. This is a bond modification. Go ahead, Bostic. Preach. Wrong.
I don't think anything has changed. Last arrest before this was in 07. Nothing new.
All right, go ahead, Ms. Rondon. What you want to change here?
Yes, the motion that I put in for Mr. Hacker is to remove the ankle monitor. The bond order that was published in May 10th of 2021 included the condition that Mr. Hacker wear an ankle monitor to be paid for by him. It has been 21 months since May of 2021, and he has been monitored by this ankle monitor without issue, paying for it this entire time. I am asking for the ankle monitor to be removed because the continuation of paying for this ankle monitor is presenting as a financial hardship to Mr. Hacker. The monitor has had to have been replaced at least once. He's had to come out of pocket for new chargers. And at this point, after 21 months with no movement on the case by the state and no issues with the monitor reported by the monitoring company, we believe it is sufficient, to take the monitor off. And so that is what we are asking the court for this evening.
All right, Ms. Broderick, last I talked with Judge McBurney and all, we kind of all agreed if it's been more than a year and there's no indictment, no violations, no reason to keep an ankle monitor. And so this has been 21 months. What's your position?
Well, our position is that the ankle monitor was put on to monitor the defendant until the case has been resolved. If there are financial hardships that prevent Mr. Hacker from continuing to pay for the monitor, it seems more appropriate to have the county pay for the monitor instead of removing it altogether, because the reason why it was put on still exists. And so we don't see a reason to have it removed. If the need is for him to not have to pay for it anymore, then there are other alternatives or options to that financial hardship than to remove it. So we don't believe removal is appropriate, Your Honor.
So, like again, I spoke with Judge McBurney and I had a long conversation, and this incident date was February the 20th, alleged incident date was February the 20th, 2021. So this is February the 27th, 2023. If there's been no violations and you still have the bond conditions. I didn't set this bond, but someone else
And Your
did.
Honor, if I may add, in addition to this being a financial hardship on him, Mr. Hacker does work for a furniture moving and shipment delivery company, and the ankle monitor being attached to him has interfered with his ability to work and keep his employment. And so for the employment purposes and the fact that it's a financial hardship for 21 months, that is why we're asking for the monitor to be removed.
So like I said, I'm just going to base this on the fact that I had that conversation with Judge McBurney, and there hasn't been a violation. And oh my goodness, Miss Rockwell. So where does he live, Miss Rondon?
He lives here in Fulton County. And Mr. Hacker can double confirm this address, but I have it as 6330 Peachtree, Dunwoody Road here in Atlanta.
Okay, so we'll just keep the other conditions and no further contact. I'm just going to add no drugs, no alcohol, no weapons. I'll still keep that no further contact, but we'll remove that ankle monitor if you want to just submit that order, Miss Rondon.
You would like me to submit the order to you?
Yeah, I think you have to submit the order.
Okay, I'll submit that to you tonight.
All right, thank you. Thank you, Mr. Hacker. Have a good evening. All right, do I have Mr. Moran? Got you. What about Thomas Aiken?
Yes, I'm still here. Before we get started on this hearing, I would respectfully and also urgently request that we be allowed to approach the bench, myself and Ms. Broderick. There's a pretty urgent matter that I'd like to discuss off the record with you, if possible.
All right, let me see. Let me make breakout room. Let's see, Broderick. I'll move us into a breakout room at that. Thank you, Ms. Rondon. You can leave. So can you, Mr. Hacker. Let's see.
Thank you, Judge.
Thank you, Aaron. I apologize for the inconvenience.
That's okay. No, just let me find yours. All right.
All right. I got the invite. I'm joining.
All right. Be right back, Ms. Robinson.
I couldn't.
Miss Clark, once court is over, can you stay back so that I can ask you something really quickly, please?
Yes, ma'am.
All right, so Mr. Moran, you and your client can leave. You're gonna address stuff with Ms. Broderick and Mr. Hutchison, and then if you folks work something out, you can send a consent order to me and I'll sign it.
Thank you very much, Your Honor, and thank you, Ms. Broderick.
All right, thank you. Have a good evening.
You too.
All right, so here we go. Last but not least, Ms. Rockwell. Ms. Rockwell. Hey, Ms. Rockwell. Okay, we got Robert Ragland. Let's see. Thomas Holmes. We have a Tony Curb on here. Is that one of yours?
It's Troy Curb, Judge. Troy Curb. I have two actually.
All right, Bostic, this is
Let me
number
just
one
get-
on the bond modifications. Troy Curb, 22 CP 209655, escape. He's out on a $15,000 good bond. Anything I need to know, Bostic? Preach. Rob.
No new arrests. Last arrest before this case was 2017.
All right, how many words does she have, Bostic? 25 or 30?
But she done used most of them up during the course of the calendar, Judge.
Go ahead, Ms. Rockwell.
So, Judge, he does have a ankle monitor paid for by the county and would really love to get the monitor removed. I do want to say one thing. The case has kind of got some age on it, the escape, just so I can inform Madam Prosecutor. He had a warrant because he was on at a transitional center and left the center. And when they caught him after he left the center, once he was rearrested, they just gave him his time and he went out and finished his time. So for some reason, they never resolved the Fulton case. I wish they would have. He tried to get back in court, etc. So the case does have a little bit of age on it. He is gainfully employed. He's 33 years of age, born in Cobb County, went to Satellite High, got his GED in 2018. He did obtain his welding certificate. No, not married, no children. Lives at 1292 Apple Lane in Lithia Springs, 30122, and works construction at KR Whitworth Construction Company. He is about to be, because he's such a valued employee, he's about to be sent on trips and work trips to Arizona, etc. He has an ankle monitor and he's got a 24-hour curfew, and he's been out about 6 months. So I can't really use the McBurney, has he been out long enough with no indictment? I'd love for them to indict it tomorrow. I'm just asking for a removal of the ankle monitor. Not sure what their, he doesn't need to stay away from anywhere. Not sure why they need to track his whereabouts, but he does, Judge, he hasn't violated his ankle monitor. He called me one time panicking because his battery had died, but the ankle monitor company saw that he recharged his battery very, very quickly. So he's been a very good candidate. I would just ask for the court to consider removing the ankle monitor.
Ms. Broderick, I remember this. This was something about a transition, yeah, and whether or not they were going to dismiss the case or whatever. I don't. Have you spoken with Mr. Hutchinson or anything to try to work this case out?
I tried to get in touch with Tom White, and he was out ill for a minute on that. So we could just hurry up because he did have to sit the requisite 90 days. He, he sat because it was escaped. It looks bad because the charges escaped, but I mean, it was merely him not coming back to the transition center. He escaped from a facility where you can really come and go as you please. So that's what we're talking about essentially.
But you obviously got to go back.
Yeah, you do.
Ms. Broderick.
Your Honor, the fact that the defendant is actually talking about traveling outside of the state, and we're talking about an offense of escape and not coming back when you're supposed to, is evidence right there that the monitor should stay on. Once we get it resolved, then that's an issue where we don't have to keep track of Mr. Curb. But until then, I think he arrived at the center in February. He walked away 4 months later. And so until we deal with that, he still needs to be monitored by the court, especially if he's talking about traveling outside of the state. I haven't heard anything that would warrant removal of the monitor. The fact that the charge is escape says that we need the monitor so that we know where he is. Your Honor, so we would ask that you keep the monitor on.
Ms. Rockwell.
Well, I mean, y'all are allowing him to work, and he would be just going with his work crew for this for this move out of state. So obviously we're gonna get with the ankle monitor company and make sure they know exactly where he's going and what his hours are going to be, etc. And we'll resolve that in that fashion, Judge. But if the court is not inclined to remove the ankle monitor, I would like, instead of a 24-hour curfew, I would like it to be a much less curfew. He is going to remain gainfully employed. He has not committed any new offenses. Remember, his offense, his last arrest was from 2017, and that's really where he had, kind of kind of floated away from the transition center.
So, Ms. Rockwell, I gave him time to leave for work. So what is it that you're wanting? I mean, as long as he supports his...
I would like for it not to be a 24-hour curfew. I would like for him to, have a curfew from maybe 9 p.m. and that he can leave at 6 a.m. if that works with his work schedule. And no further violations of the law. Obviously, no drugs, no weapons, no replicas of weapons, and no anything else the court feels like would be something that would make the court comfortable. I would love for him to, if he was indicted, we could even waive the indictment. I'm sure that would give him straight probation. I mean, he went and served time after he allegedly escaped. He just went down the road and finished out the sentence. So, imagine if he was on straight probation, Judge, he would be seeing a probation officer probably once a month. Maybe they'd even put him on call-in. I don't know. Remember, his last offense was in 2017, which was a good little while ago. So if the court's not inclined to remove, could we have a 9P to a 6A?
Well, is that going to make him be able to work? I mean, is that going to fit in his work schedule?
Well, Mr. Curb, can you tell me, does 9 p.m. and leave at 6 a.m.? Do y'all leave earlier for a, obviously he would.
A lot of times. I'm sorry. A lot of times I'm at work until about 7 or 8 o'clock at night.
Okay. So what I'm saying is, do you think you could get home by 9 p.m.? Would that work with your work schedule? And do y'all ever start work? If you left your house at 0600, could you get to work on time?
No, I leave my house at 4 o'clock in the morning.
Oh,
right,
geez.
let's just mute him. All right. So, Ms. Broderick, how about this? Here's the thing. If he's been leaving for work, he's supposed to have let the ankle monitor company know his schedule anyway. Am I right?
Right.
So, we could do it like, 9 p to 6 a.m. And if his schedule is going to be different, he has to let the ankle monitoring company know. And you, Ms. Rockwell, said you can let Ms. Broderick know.
Okay.
Or whoever in the DA's office knows. Is that good with you, Ms. Broderick?
Right.
Yes, Your Honor.
All right, 9 p.m. to 6 a.m.
Okay. In other words, he can't leave at 0400 to go head down to Pensacola Beach.
Well,
as long as he's going to work.
As long as he's going to work, but no, not on any kind of vacation. Absolutely not.
Okay. I understand, Judge.
But he still, if he has to leave
6
early, he has to let them know what he's doing, okay?
I understand. And
right.
and he will do that. Thank you,
Right.
Judge.
All those other conditions remain. So just submit me that order. Okay, you can leave, Mr. Curb. All right, so I've got Ms. Fisher. It's position 3, Bostic, 22 CP 207-840. is it Nema Fisher, aggravated assault with deadly weapon, possession of firearm during the commission of a felony theft by receiving stolen property. She's out on a $40,000 good bond. Anything I need to know? Petro?
No.
So much enthusiasm. Go ahead, Ms. Rockwell. Where is your client? Ms. Fisher, you need to turn your camera on. Ms. Fisher, turn your camera on.
Judge, she might.
All right, go
Okay,
ahead.
there
She's
we
got
go.
it. All right, go
Judge,
ahead.
for the record, my understanding is she's 39 years of age, born in Seattle, went to Westlake, graduated in 2001, then attended Atlanta Area Tech, where she got her degree in health information management. That degree she obtained in 2016. Is not married, but does have a 13-year-old son. She lives with her son. She's actually a tax preparer. And my understanding is she's not on probation, parole, or any kind of suspended sentence. She does not have an open case. She does not have any prior felony convictions. It is an aggravated assault. She does, and I heard another lawyer speaking this evening, she does have a co-defendant who does not have an ankle monitor. So she, does have that argument. It was a situation like in the other case that we spoke about tonight, when they were arrested and happened to go in front of separate judges. So one got the ankle monitor, one did not. She's requesting a removal of the ankle monitor. She did get arrested on 3/25, got out on 7/7. So we're going on a year, almost a year, without an indictment. And the request is to remove the ankle monitor. I may have a backup request if the state is opposed to that, but it's because the co-defendant judge has a different bond condition. We're requesting the same.
All right, and the theft by receiving stolen property looks like on this bond order, it ended up being dismissed. So, Ms. Broderick.
Your Honor, I haven't heard a reason why the monitor should be removed. The fact that a co-defendant doesn't have a monitor doesn't necessarily mean that that's what's best in this case. And so without hearing anything as to why the monitor should be removed, it seems as though it's reasonable for the court to deny the request to remove the monitor.
I don't even see where I mentioned the co-defendant, Ms. Rockwell, in the bond that I set in June of last year.
I didn't really hear you, Judge.
I said I don't even see a mention of the co-defendant in the bond that I set last year, but what else?
She's staying away from the co-defendant, Judge. Okay. I do have contact with the co-defendant's attorney, and I know you don't care about the co-defendant, 2 cases where nobody wants to testify. I know you don't care about all that. That's not what this hearing's for. If the court is not, we're coming up on a little less than a month, coming up on a year. If I can come back and address the court's not inclined to right now regarding that without indictment. I would ask that the curfew, instead of a 24-hour curfew, the curfew be changed, just like Mr. Kerb, 9 p.m. to 6 a.m. I know she does have a child. I'm not sure, Ms. Fisher, what time she leaves to make sure the child gets to school versus what time she has to get to work. I don't know if that works for you, Ms. Fisher, 9 p to 6 a. And I can't hear from her.
Okay, you said because she has a child.
I don't know if she has to leave any earlier than 0600 to get her child, because I did come back one time before. You are allowing me, she's a single parent, she is just her and her child. You are allowing her to go and deal with the child's schoolwork, etc. You're also allowing me to go 1 mile off track,
right?
Either where she starts or where she ends for basic necessities. So I would like the curfew be removed, seeing how we're going on almost a year, no indictment. And if we could go to 9 p to 6 a instead of the 24-hour curfew.
Ms. Broderick?
The fact that she has a child and she's allowed to leave for necessities, and she can leave to go to work, it still doesn't, I guess, support a change in the 24-hour curfew. I still think that the 24-hour curfew is acceptable under these circumstances.
I see I've let her go like Thanksgiving and things like, how old is her child?
13 years old. And you know, these 13-year-old, they're not that there's nothing wrong with a 13-year-old. They're just getting a little more needy and a little more complicated than a 6-year-old, where you can tell them this is what we're doing and this is where we're going. 13-year-olds, in other words, she can't even really go to the mall unless she clears it with the company. We got 1 mile at her start and 1 mile at her finish that the court's allowing me to step outside of the box. And I still don't know the difference, why there'd be a difference between her and Mr. Curb. Matter of fact, she's been out even longer than Mr. Curb without indictment.
So once again, why don't I just do it like 8 p.m. to 6:30 a.m. So she has a 13-year-old that may be involved in some sort of extracurriculars or something like that.
That's fine. And I will direct her, Judge, I'll prepare the order, but I'll direct her to still, in keeping with your prior orders, all of the conditions remain the same.
Right.
In keeping with your prior orders, just to get with the bonding company, the monitoring company, in the event there are necessities that are legitimate necessities for the child. You did allow that, Judge.
Right, because I did put like school and back, groceries, things like that. Right.
All right, I'll submit the bond order, but it probably will not be tonight, Judge.
No, that's fine. Anything?
And I'll copy Ms. Broderick on it.
Okay. Anything else?
That's all, Judge.
Ms. Broderick, anything else from state? We have anything else? Ms. Rhonda, did you have anything else? Thank you, Ms. Fisher.
Yes, actually, I had 2 questions. Is one for Mr. Hacker. I already forgot. Did you add another condition of no weapons? Or am I making that up?
Let's see. Mr. Hacker, hold on. Wait. Oh, yeah, no drugs, no alcohol, no weapons.
Okay. I just wanted to make sure I included that in the order I submitted.
But yeah, removing the ankle monitor since it's been a while.
Okay. And then if we were completed with the calendar, I was hoping to ask about something off the calendar.
Sure.
Okay, I forwarded you an email a few moments ago because I realized I hadn't sent it to you earlier, for a motion for a client, Mr. Devontae Johnson, to temporarily leave the state of Georgia for about 4 days to attend his sister's wedding in Wisconsin.
Judge, I'm sorry, Ms. Rhonda, if I could briefly interrupt. The motion that she forwarded to me, it is a motion that was reviewed by Judge Drake's office. And I think Judge Drake weighed in on that motion. Those are the motions that she reviewed. If they're emergency motions or any type of, motion to remove bond or modify the bond, and then they're sent to us based on her review of that. And I think Judge Drake has already reviewed the motion and made a ruling regarding that.
Do we know what the ruling is?
Let me just look at her spreadsheet. She sent out the spreadsheet. Let me just go back to her client because I think she already made a determination.
Oh, thank you. I didn't realize Judge Drake had already looked at it.
I didn't either. I don't necessarily have a problem with it. If Ms. Broderick doesn't, I mean, as long as typically if it's something like that, let them go as long as they provide the location and the schedule or what their itinerary is. Oh yeah.
I don't see anything filed in Odyssey, but if she only looked at it today.
Because this is March the 4th. Ms. Broderick, do you have a?
Your Honor, I can't actually speak on it considering the fact that I'm not familiar with the case. I haven't seen the request, so I wouldn't feel comfortable one way or the other providing my recommendation.
Judge, according to the notes that I have from Judge Drake, she said that the motion was filed too late. There was no further action needed at this to be taken at this time.
Ms. Ron, it's his sister's wedding. Ms. Broderick,
unfortunately, Mom only let me know over the weekend, and so that was all the notice that I had. And I mean, I can ask the mother to join the Zoom call. I did let her know that I was going to be asking Your Honor about this evening, and she let me know that, you know, Mr. Devontae Johnson, he's 17, and this is his first charge. He was released from the jail on a UJR pretrial supervision level 1. Pretrial was okay with him leaving the state, but they told me, you know, the motion needed to be filed. And I mean, the parents say they don't want to miss their only daughter's wedding, but they also don't want to leave their son home alone at 18.
So when is so I saw the order and it looks like it says can you just send an order that's a little more
specific? I can.
Yeah, like
the family is
things like that. What are his charges? I'm trying to pull this up.
It's possession of purchase, possession, manufacture, distribution of marijuana, and the circumstances surrounding the case is a vehicle was pulled over. There are 4 co-defendants and no one laid claim to the marijuana, and so all 4 individuals were charged.
You see it, Ms. Broderick? And
I'm looking at the email that was sent over with the request. And Ms. Rondon, did you say that this is his first arrest?
That I'm aware of, yes. And he was released on a UJR pretrial level 1.
Bostic, do you see anything on the? Is Bostic still here? Bostic, you see anything on there?
I'm here. What's his name?
His name is Devontae Johnson. Johnson is spelled the normal way. Devontae is DEVONTE. His birthday is March the 15th, 2005.
So you're telling me that if the son doesn't go because of his age, then the parents are going to miss their daughter's wedding.
Yes. And the mom was in near tears talking to me if that was going to be her option.
I get it.
Because she doesn't want to leave her son home alone, which I agree with.
Your Honor, I have no opposition.
All right. Yeah, Ms. Ron, if you just want to put Bostic, did you see anything?
Yes, Judge. At this point, what I'm looking at, we have no opposition either, Judge.
Okay. I mean, yeah, I'm not without a heart, obviously. Weddings. Hopefully it's only the only wedding her daughter will have. You know, that's my wishes for her.
Judge, and he's been compliant with pretrial, so we have no.
Okay. Yeah.
And with his ankle monitor.
So Bossy, you just wanted to say something like when he's going, when he's coming back. Is that good enough?
Just put the time frame.
Okay. Yeah, just send me that, Miss Ron. When is he going to leave, Miss Rhonda? Do you know?
Okay. Yes, the family wants to drive up there. They're going to leave Thursday morning.
Okay.
The wedding is on Saturday, and they're going to start their drive back either Sunday night or Monday morning.
Yeah, just send me the order. Just email it to me, and I'll sign it and get it back to you.
Okay.
And that way
fantastic. Thank you so much.
All right. Anything else?
That was it for me.
Judge, I just had a question. Once we hit that 1 year for reconsideration, no indictment, can we address that on more or less an emergency basis, or do we have to wait the 90 days? It's just the issue's gonna be 1 year without indictment.
I mean, I think if you just can get your motion and ask to be put, like, if the 1 year is going to be in June, you just email, file your motion and ask Mr. Roy or something like that to be put on like a June calendar.
Mr. Who?
Miss Robinson, Mr. Voria, just ask her to be put on.
Oh, Miss
Yeah.
Travoy. Okay, got it,
Yeah,
it.
something like that. That may
Okay.
be, or however she wants you to do it, so we'll know it's more than just, so we'll get it closer to the year. Because I mean
Okay.
Gary and I had that conversation. We both agreed that,
Okay, thank you,
that's only
Judge.
fair. Okay.
I
Anything?
appreciate it.
Sure. Anything else?
Yes, one question, Judge. Can we get the total amount for Brandon Richardson? Was it 50,000 total for the bond? It was 2 counts, and I think I heard 30 and 20,000.
Yeah, it's 20 and 30.
Okay, thank you.
Okay. Anything else?